Dear students, let's start the discussion on today's newspaper, that is 10th February 2017. The first article, The Temptation to Go Viral, it is related to Good Samaritan law. Now, we see on a day-to-day basis accidents on the roads, but very few bystanders come to help the accident victims. The major reason is the fear of law. They will be unnecessarily dragged into these legal procedures, keeps them away from helping the victim. In this context, the Karnataka state has passed the Good Samaritan law. The Supreme Court of India also has directed the center to frame the guidelines to protect Good Samaritans from unnecessary legal harassment in 2014 itself. Based on that, Union Road Transport Ministry has notified the guidelines in 2015. In 2016, the standard operating protocols are being given, and Supreme Court also has held that this SOP and guidelines will have an effect of law. It means that the Good Samaritans are being protected now by the law. So this article very much looks into this Good Samaritan law, but the indifference of the people to the accident victims in spite of the Good Samaritan law. So now we study about the Good Samaritan law over here. Already we have discussed this in the previous videos. Now let's revise it again. So what are the protections given to the Good Samaritans? I am dividing that into three levels: police level, hospital level, and then at the court level or at the judiciary level. So at the police level, a Good Samaritan is not liable to any criminal action for any injury or death of the victim. Now, a Good Samaritan who informs the any emergency department need not state about his personal details, and disciplinary action against public officials, if they coerce or force the Good Samaritans to give their personal details, is also part of the law. Now, when a person goes to the hospital, a Good Samaritan shall not be asked about his details, even if it is a medical legal case. And second is, he is not forced to pay any registration fees or any other part of that. And finally, hospitals cannot refuse the treatment to a victim. If anything of this is done, it can be considered as professional misconduct. When you go to the judiciary, the Good Samaritan has a choice either to be a witness or not. If he is a witness, if he wants to be a witness, he can give it in the affidavit or before a commission or through video conference. And once he gave that affidavit, he shall not be asked again and again for the same. So in that way, the protection exists at the three levels: police level, hospital level, and judiciary level. In spite of this, why the victims are not getting help from the bystanders? One is, it is not just protection, an attitude of initiative also need to be nurtured. Now, the police need to be trained that there is a Good Samaritan law. It means that we have to ensure that the change in perception of the state agency is required, so that people also change their perception about the protection they get from police or other agencies. So these things we need to do. And coming to prudence amid uncertainty, it is about monetary policy. You know that monetary policy stand is more neutral rather than accommodative now. Nothing has changed. So in spite of huge money available in the banks in the form of deposits, the interest rates are not being decreased. The major concerns are related to inflation. You know that the monetary policy's primary target today is inflation targeting. So the failure to control the inflation or else international uncertainties, increase in interest rates in the United States of America, and the increase in commodity prices, oil prices, and mineral prices, and food and fuel expenses, all these shows that in the future we have to face inflation uncertainties. So in this context, the monetary policy stand is more safe rather than being growth provocative. Now, bowing down on to patriarchy. Already I have discussed the Article 371A 2 days back. Under Article 371A, the protections are being available to Nagaland, and parliamentary law cannot get into Nagaland unless state legislature approves the same. Here, the social and customary law, justice delivery, and ownership and transfer of the land. These can be protected. So, based on this, finally a Nagaland state was created, and it was kind of a solution to the Naga problem. And in this, Part 9A of the Constitution, it provides for reservations to women. And the Naga tribal groups, they claim that it is against to the customary law of the Nagas. Here we need to understand that the protection is given against the parliamentary law, not against the Constitution of India. These protections are being provided to Nagas in return for their abidance to the Constitution. So, in this context, the women reservations, which are Part 9A of the Constitution, are legally applicable to Nagaland. And Supreme Court also has provided that elections to the urban local bodies have to be conducted. In this context, Naga Ho has led to a violation, and government has requested the union to exclude Part 9A or Nagaland from the purview of Part 9A of the Constitution. So, we need to make one serious statement over here. That is, the women reservations and empowerment shall not be subjected to the debates of autonomy or debates of culture. So, any culture or society has to change as to the changing needs of the people, and the constitutional principles of equality based on gender need to be protected. Now, coming to the perspective page, you know that the President Trump, he has nullified America's engagement in Trans-Pacific Partnership. According to him, it goes against the workers. At the same time, he also reiterates that American corporates need to get their due share, and he recommends for the strengthening of the intellectual property regime. In this context, though TPP is dead, the intellectual property rights are still hanging on India. What are the provisions of the TPP that are worrisome? That is, intellectual property rights have to be extended for next or more than 20 years is the first condition. And the second is data exclusivity. It means that whatever the clinical trial data in the process of development of a drug is developed will be used only by that company. As of now, this clinical trial data shall be kept in the public domain. There is an exclusivity on this data for the parent company according to TPP. Now, if a generic drug has been developed, if its efficacy has to be proven, then we can depend upon the already conducted clinical trials. That is been done away with under data exclusivity. And third, a kind of a difference is made between biologicals and chemical drugs. The biological means where a living organism is used to produce the drug. If you talk about a plant or a vaccine which are being used to produce the drug, they come under the definition of biologicals. So, though the TPP is dead, now we have the other things which are living, that is regional comprehensive and economic partnership under the leadership of China. Here, South Korea and Japan are also the partners. The South Korea and Japan are pushing for the provisions of TPP related to intellectual properties under this. So it means that the corporate control over the medicines is bound to increase, and the cost of drugs is going to go high up and up. So it will be a public health concern for many developing countries. In the case of intellectual property rights, whenever there is evergreening of patents, it means that without really changing the pharmacodynamics, just changing the peripheral components to get the fresh patents can be fought. But that is not the case in the case of data exclusivity. So that's why these are much draconian than the intellectual properties which are being guaranteed. If you see the Gleevec controversy in India, Gleevec has tried to prolong its patent by peripherally changing the drug formulations. So then finally Supreme Court stated that is evergreening of the patents and allowed for the manufacturing of the drug by the generics. But no such a thing exists in the case of data exclusivity. And it is also morally incorrect because when an efficient drug is available, subjecting the people for the clinical trials is not acceptable. An eyewash or a turning point. This is about arrest of the Hafiz Saeed in Pakistan. So this arrest is majorly due to the international pressure related to Money Laundering Act, violation of the provisions of money laundering by the Jamaat Dawa, the organization headed by Hafiz Syed. So, under this international pressure, Pakistan has kept him under house arrest. It is just a tactical move to appease the international community. There is no fundamental change of Pakistan with regard to its strategic intent to use the terror as a state policy. So, India need not gain or will not gain much from this particular move. And now, I gave you the notes over here. In these notes, I have covered for the Good Samaritan law. So, in the last, before or else in last 3 days notes, if you go through, in that I have covered you for Article 371A, what are the provisions of Article 371A, and please try to take that particular notes from there. And then I have discussed about TPP and what are the provisions of the TPP with regard to intellectual properties are being considered. So try to go through the notes, and this notes is available to you at laix.in/civilsprep. Thank you very much and all the best.